Hello, everyone. Welcome to the webinar. My name is Sarah Weeder, and I'm going to be acting as kind of a host and moderator today. We are so lucky to have attorney Shannon O'Keefe with us. She's from Johnson Law Group, and she is going to be talking with us about the importance of estate planning. She has been really a wealth of knowledge throughout for multiple clients in their estate planning process. So we are very lucky to have her here. So I guess, Shannon, I'll let you go ahead and get started.
Okay, awesome. Thank you, Sarah. And hi, everyone. Welcome to today's webinar, like Sarah said, on the importance of estate planning. And hopefully you can all see my slides and you know what this webinar is about. Before we get started, just a quick reminder that this presentation does not constitute legal advice, nor does it create an attorney-client relationship, but I do appreciate you all attending. All right, so let's get started. First big question that we have to answer is, what the heck is estate planning? Generally, it is establishing how you would like your estate to be handled when you pass away or you become incapacitated. And the next big question people always have for me is then, what is an estate? What do I mean by that? Your estate is made up of your assets. So your real estate, your land, retirement and investment accounts, banking accounts, vehicles, personal property, and personal property is a really big umbrella term, but it includes jewelry, artwork, sentimental items, any small physical item that you can move. These things constitute your estate. Anything that you can think of that you own is part of your estate. But what I don't want you to do is let these first two bullet points about estates fool you. We focus on the word estate quite a bit. That's why they call it estate planning after all. But planning does not just address your financials. It can also, and it should, address your well-being as well. So these are some of the common estate planning documents that you'll have and will be drafted, including a will or a trust, a medical power of attorney, a general durable power of attorney, aka a financial POA, and an advanced medical directive, which is also known as a living will. And we're going to go through each one of these separately, starting with wills versus trusts. One of these or the other will be what I like to refer to as your anchor document. It is the main staple of your estate plan. And at their most basic, these instruments accomplish similar things. They describe your estate, they outline your beneficiaries, and they name a representative to manage your estate. But there are key differences between these documents, which are listed in the table here. The first difference is the effective date of the instruments. A will is effective upon your death only, while a trust can be effective at your death and upon your incapacity. A second difference is that in order for a will to be effective, you have to go through a process called probate, while for a trust, you don't need an extra proceeding. So then the question is, what is probate? It is a court proceeding where a judge will determine your intent based on the provisions of your will and enter orders regarding the distribution of your estate. For a trust, you don't need a judge involved. The third difference is that a will is not private. Because it has to go through the probate process and probate proceedings are open to the public, this means that nearly any interested party can enter in the case and gain access to the terms of the will. A trust, however, is a private document that goes only to your named fiduciaries and any other person that you deem fit to tell about the trust. Contestability is a biggie. The fact that a will is public also means that you have a sort of open invitation for people to come out of the woodwork to contest the terms of the instrument. All of a sudden, Uncle Buck out in Nebraska is entering into the case and making a claim that just before you died, you actually revoked the will that has been filed with the court and sent him a handwritten note leaving him everything. So high contestability with wills. Conversely, if someone is not named the beneficiary of a trust, it's much more difficult procedurally for that person to contest the terms because there isn't already an avenue for them to do so. There is no court proceeding. There's no probate case. Moreover, most trusts have a provision that states that if any named beneficiary contests what's allocated to them in the trust, they will lose their interest altogether. So there's a low risk of contestability with a trust. The last major difference I have listed here is level of control. A will dictates what assets will be distributed and to whom, but has very limited ability to set conditions on how and when distributions will be made. So there's low levels of control with the will. A trust, however, allows you to place a variety of conditions on disbursements. It allows you to structure them so that a beneficiary will not have more money than he or she can handle, and it can protect assets from being seized by your beneficiary's creditors. So high level of control with the trust. These are just a few major differences between trusts and wills. There are more, but it would depend on the specificity of your instrument that you need for your particular circumstances. But like I stated at the beginning of this slide, you should have one or the other, and something is certainly better than nothing. Second major document is the General Durable Power of Attorney, which allows you to select an agent to make financial decisions on your behalf. And your general POA can be effective before or after incapacity. Most people want their financial power of attorney to be effective only upon incapacity. Otherwise, you're authorizing someone to manage your finances without your input or your explicit permission at the time of taking action. And that's not control that most people want to surrender or share while they still have the ability to make decisions for themselves. Some common areas where you can authorize your agent to act include buying and selling property, entering into contracts, engaging in litigation, managing banking, investment, and retirement accounts, managing or seeking government benefits, making gifts to people, and providing for the support of dependents. So that's what this document will do. Next is your medical power of attorney. And much like the financial power of attorney, it also allows you to select an agent. This agent will be authorized to make medical decisions on your behalf in the event that you're incapacitated. And some common areas of authorization, this is where our conversation kind of turns to the more morbid. Estate planning generally focuses on financials, but when you're talking about medical decisions, it can be a little bit uncomfortable to think of these issues. But these are some common areas, including amputation of limbs, artificial nourishment and hydration or artificial life support, assisted respiration and ventilation support. This includes your do not resuscitate and CPR directives, admission into treatment facilities, administration of drugs or use of pharmaceutical products, disposition of your remains, and receipt of protected HIPAA information. The last major estate planning document is the Advanced Medical Directive, which I stated previously might also be referred to as a living will. The Advanced Medical Directive and your medical power of attorney often work together. Under your POA, you're selecting someone to make decisions. In your AMD, you're providing guidance about what kind of care you'd like to receive. So the Advanced Medical Directive will outline your preferences in the event that you are incapacitated, in a persistent vegetative state, and or you have a terminal condition, and you're in need of a life-sustaining procedure and or artificial nutrition and hydration. So for example, a circumstance that might arise is you're incapacitated, so you can't make medical decisions on your own behalf. You have a terminal condition and you're in need of a lung transplant to survive an additional 6 months. What decision do you want your agent to make? This is the document where you're going to state your preferences. One more thing that an Advanced Medical Directive does is it outlines your preferences for making anatomical gifts. Do you want to be an organ donor? And if yes, under what conditions, if any? For example, do you only want to donate to named family members? Do you only want to donate for medical research? Do you only want to donate some organs, but not all? Again, morbid, but think about heart transplants versus donating your eyes or your skin. These are somewhat outside the scope of ordinary organ donations that most people think of, but you should think of it and include it in your Advanced Medical Directive. The next question we should answer is who needs an estate plan? And my short answer is everybody. There are consequences if you don't have a plan in place. If a loved one, for example, passes away without a will or a trust, so the main staple instrument that you have that anchors your estate plan, the court will apply something called the laws of intestate succession, which imagine how the average Joe would like their assets to be distributed. So here are some examples of the default rules. It's not an exhaustive list, but it's a major list, I'd say. If you have children but no spouse, everything by default will go to your children in equal shares. If you have a spouse with children from the same spouse, so all of your children that you have are with one person, then everything will go to your spouse. If you have parents but no spouse and no children, your parents will inherit everything. If you have siblings but no spouse, no children, and no parents, your siblings inherit everything. One last point though about intestate succession, just remember, this is if you have no plan whatsoever in place. And if you have no family, then your property could go to the state of Colorado. It's a last resort and it's rare, but it can happen. It's also important to note that there is no intestate provision for friends or charities. So your friends are not going to inherit anything by default, even if you have no family. There's no way for the state to figure out who those people are if you don't have something written down. Another consequence outside of just your will or trust, if a loved one becomes incapacitated without any powers of attorney, so the financial power of attorney or medical power of attorney that we were discussing in previous slides, you may have to go through a conservatorship and or a guardianship court proceeding in order to gain authority to assist them in managing their financials and health. So instead of just having a document that automatically authorizes you to make decisions upon incapacity, you have to go before a judge, and that can take a long time. And you might not have a lot of time to make these kinds of decisions. So these are the consequences. But instead of just mentioning the consequences, which can be scary, it's also helpful to think of the benefits because there are many. This is not an exhaustive list, again, of the benefits of estate planning, but some major points here. Number one being that you can protect your young children. Think if something happens to you, God forbid, who's going to pick your kids up from school? Where are they going to sleep on a temporary basis? Who is going to care for them long term? You can also give your loved ones peace of mind and save them from having to make tough decisions without any guidance from you. You also prevent them from having to make these difficult logistical decisions while they might be in the middle of grief. Estate planning can also help reduce taxes, can help you avoid court altogether, which is meaning that you're avoiding a time-consuming, stressful, and costly process. It also ensures that your assets are distributed as you intend. So not just how the state of Colorado thinks you might want your assets distributed by default. And then finally, a big one here is supporting your favorite causes. If you want to support any charities with assets from your estate, that's very easy to do in an estate plan. So that's a very basic overview of estate planning and why it's important. I'm happy to answer questions at this point of the webinar, but if you have questions that are specific to your circumstances or you'd rather speak in private, it may be best to give us a call so we can schedule an initial consultation.
Thank you, Shannon. So I am seeing one question about the best way to contact us. So you can definitely give us a call. Our number is 720-452-2540. You can also email us at info@johnsonlgroup.com. And we can definitely, put you in touch with Shannon if you'd like to speak with her. She can answer any questions that you have. And she can also get you started if you would like to get started with your estate planning. I am not seeing any other questions. I feel like you're right, Shannon. It's more of a specific questions that people are going to have. So I wanted to thank everyone for attending. Shannon, thank you so much for presenting. We are so lucky to have you. And all of you will be getting an email following this presentation with our social media links. You can follow us on there. We have some more upcoming webinars. You'll definitely be seeing Shannon again in some webinars in the future. So we hope to see you all there, and I hope everyone has a wonderful day. Thank you, Shannon.
Thanks, Sarah. Bye-bye.
Bye.